So yeah, there's more to the honey lawsuits, and we're going to do this together, so let's do this together. Okay, so we go to Court Listener. Here's what I found. Wendover Productions v. PayPal. So filed December 29th, and we went over all of this stuff. What's happened lately, there has been an administrative motion to consider whether cases should be related. So here we have the list of related cases somewhere in here. Wendover Productions, Businessing, The Charismatic Voice, Clear Vision, Gear Live Media, Now, Eli Silva, Ashley Gardner, GamersNexus, Claudia Jane Young are all plaintiffs in similar cases. The Silva, GamersNexus, Young, and Wendover actions name overlapping defendants and include substantially similar factual allegations. The use of the Honey browser extension allegedly misappropriated sales commissions that should be awarded to online marketers, including plaintiffs and class members. So they're notifying the judge that there are other cases for the same thing. So now I'm super interested in whether there are more of these cases against PayPal. So I want to look at all cases that were filed against PayPal since the 29th. Just might as well go to courtlistener.com again. Recap archive. And let's do party name PayPal. And filed after the, it says after, so after the 28th. I guess we'll make it the 27th. And so all cases with a party name of PayPal after the 27th. So we have Coleman versus PayPal Holdings. I'll open that one up. We have Young versus PayPal Holdings. I think we just saw that one. We have GamersNexus versus PayPal Holdings. We have Desai versus PayPal Holdings. And we have Silva versus PayPal Holdings, in addition to the Wendover action. I'm just going to go through them one by one and see what's going on. I guess starting with GamersNexus, since I know who they are. So this was filed January 3rd. Summons issued to PayPal. Order reassigning case, deferring ruling on related cases. So now they're all filing the related case stuff, which is why you saw it pop up in the Wendover case. So here is the GamersNexus complaint. Honey is a popular web browser extension. PayPal acquired it. The terms of use state that PayPal does not charge fees to you for its service. E-commerce affiliate commissions power much of the content ecosystem. The affiliate commissions are paid by last-click attribution, and then they're going to go into the same allegations that the Honey extension stole the last-click attribution either through the URL or through a cookie or through another method. The GamersNexus complaint includes exhibits. Just one click. Here's the Honey browser extension in Chrome on a Mac. You activate it, 5 coupons found, apply coupons. We searched for something, but we didn't find it. Rewards found. It's showing how it works. If you've used Honey, this is how it works. They make the class action allegations, and then they start with conversion. Plaintiffs and class members possessed or had the right to possess commissions they earned from referring consumers to products and services sold by e-commerce merchants. PayPal intentionally and substantially interfered with plaintiffs and class members' personal property by usurping their commissions and referral fees. PayPal assumed and exercised the right of ownership over these commissions in direct hostility to the rights of plaintiffs and class members without justification. PayPal's wrongful exercise of control over plaintiffs and class members' personal property amounts to conversion. Plaintiffs and class members neither assented to nor ratified PayPal's interference with their referral fees or commissions. As a direct and proximate result, they were harmed. PayPal is liable. Tortious interference with contractual relations, just like you saw in Wendover. This is interference with existing relations. The content creators had business relationships with the companies that were marketing, the companies that were selling goods and services that were going to have, they had affiliate links with. And when PayPal/Honey, and you're going to see Citi is involved in this too, /Citi interferes with those affiliate links, then the business relationship is harmed. The website thinks that the content creator isn't sending as much affiliate revenue as they thought. And so Wendover Productions underperforms in theory. It should be in fact as well, but we'll have to wait to see. They intentionally disrupted the class's performance of the contractual and business obligations. Violation of North Carolina's Unfair Deceptive Trade Practices Act. GamersNexus, I'm guessing, is in North Carolina. So very similar Very, very, very similar. Almost the same. Filed by another lawyer or another law firm, series of lawyers looking for class action status as well. I'm not exactly sure what happens when there are competing class allegations. Maybe it's whoever gets there first in time. Maybe it's whoever the judge rules first. So, yeah, I think what we're seeing is kind of the race to get the class action status, because you've seen that the lawyers get a big chunk of the award, the fees involved, oftentimes making the lawyer very, very wealthy, while the class each gets a few dollars. Sometimes the self-interest of the class representatives. I am not trying to accuse anyone in this case or in any specific case, but it is often the case where you the class representative have to make a decision whether settling is better than risking trial. And so the settlement sometimes is less than the class members would have liked. So the class leader does not look as, it looks a little greedy. So just, that's what happens. That's why that happens. Let's take a look at some of these other cases. We have Coleman versus PayPal. This one, no one's downloaded the complaint. I'll download the complaint for everybody. $1.90. How much do I love you? Okay, so this is Shauna Coleman, and it makes similar allegations. This one shows the activation of the browser extension. It also shows how the cookie entries are now intercepted. Shauna Coleman is an influencer and content creator who earns commission payments from affiliate marketing on social media, including Facebook. She would have earned more had it not been for the Honey browser extension. She's from Nebraska. So here's a class action complaint out of Nebraska. Unjust enrichment basically means you got something that doesn't belong to you. It's another way of saying it. Violation of California's unfair competition law. I'm guessing they're suing PayPal in California. Interference with prospective economic relations or advance. Conversion, again, like you saw. Nebraska's Uniform Deceptive Trade Practices Act, Consumer Protection Act, etc. Young versus PayPal. Claudia Jane Young, also Northern District of California. Through a simple and incredibly effective scheme, PayPal has for years been systematically stealing affiliate marketing commissions from individuals who have built businesses and personas online and advertising relationships to make a living. Advertising relationships? Okay, that's a fun way of saying that. Let's see what these allegations are. Claudia Jane Young is a resident of Washington County, Arkansas, an Instagram creator who earns commission payments from affiliate marketing. They also go into how Honey works. And they show the changing of the cookie, similar to what was shown on the, I think it was MegaLag video. So here they're showing how clicking on Activate Rewards changes the cookie. So they also make class action allegations, of course. Their first claim for relief is tortious interference with prospective economic advantage, and then conversion, and then California Business and Professions Code, and unfair competition law, and Arkansas's Similar Deceptive Trade Practices Act, and unjust enrichment. So those are the claims that they made out in the Young case. Let's go over to Silva versus PayPal Holdings, filed December 30th, also in the Northern District of California. Very, very similar. Resident of Dublin. Gardner is a second plaintiff in Ridgecrest, and they sue as well. Now, interesting, if they're all residents of the same state, then we have to have a federal cause of action in here. Unjust enrichment would not be a federal cause of action. Where's their jurisdiction? Here's where I want to see what they said about jurisdiction. Because if we're in California and we're suing California, don't you sue under California law? I don't think you sue in federal court. I guess because it's a class action, the court has subject matter jurisdiction because of the class action status. There are more than 100 class members nationwide, and the aggregate amount is more than $5 million. Okay, that is not, like when you go over jurisdiction in law school, like you generally kind of forget about like the class action jurisdiction stuff. Haven't done it for a long time, didn't need it on the bar exam. So there you go. That's how you get jurisdiction when you have members of the class that are in the same state. So unjust enrichment is the first class claim. Violation of California's unfair competition law is a second one. Interference with prospective economic advantage. Conversion. I really liked that Wendover included the existing economic advantage as well. These things can still be amended, and you probably don't need to win on all of them to get maximum dollar. Once you establish a cause of action, you probably don't need to win on all of them because any one of them identifies the right amount of misbehavior in general. I'm speculating a little bit here, but you get what I'm saying. Why not turn this into a class action? It is. All of it is a class action. It's just in the beginning stages. A class plaintiff, a representative, class representative is the party and lawyer law firm to represent the class. They sue, they file the complaint, and then in the complaint they have to allege why they believe this should be a class action. Judges have to rule on that. There are currently now, what did we say? Several? 6? 5? And there are currently at least 5 class action lawsuits on Court Listener right now, which should be a pretty accurate representation of the actual docket, just maybe delayed by a day. So I think we're safe to say that these are the 5. And I think that's a great start, that PayPal and Honey should have to face reckoning for this underhanded theft that they've been doing. If they've been doing, I mean, I'm assuming they've been doing it. It wouldn't. I didn't check it myself, but I'm assuming that the reports were accurate, or otherwise someone would be saying the reports are inaccurate. Here's what's really going on. But wait, there's more. It turns out that there's actually another defendant, not just PayPal/Honey, but also Capital One. Let's take a look. Here we go. Jessica Broditsky and Peter Hayward from in the Eastern District of Virginia. Coupon browser extensions are widely used. Capital One's shopping browser extension automatically looks for coupons. The extension is appealing to consumers looking for a discount. It is, however, designed to steal commissions from online marketers, including but not limited to website operators, online publications, YouTubers, influencers, and content creators. Online marketers earn money through these affiliate links where they earn commissions. Capital One cheats these online marketers during the checkout process. They programmed the extension to systematically appropriate commissions that belong to influencers. Yep, it's the same case against Capital One. I don't know if they've included any further details, but it looks like it's the exact same thing. This screenshot was taken during the checkout process at Green Man Gaming after having navigated to the website with the online marketer's affiliate link. The entry cookie shows Linus Tech Tips, and then once activated, shows Capital One. There you go. Doing it again. Same thing. Stealing the affiliate links with your browser extension. Selecting the no thanks, activate rewards will also cause the referral click. So Broditsky and Hayward receive commissions payments and believe that the Capital One browser extension has stolen their money. It probably has, assuming that this is true. And then they show specific examples of it happening to them. This is a little bit different than the other lawsuits. And they also make class action allegations. And they start with, the applicable statute of limitations has been told by defendants knowing and active concealment. This lawsuit makes allegations of the tolling or the concealment, the tolling of the statute of limitations and the concealment of the facts. And therefore, these plaintiffs should be able to go backwards in time. Do you remember we had a case about this in copyright? My channel's more about copyright law. And the question was whether you could go back farther than the 3-year statute of limitations for certain kinds of piracy because the pirates hid their identities behind an internet IP address. An IP address? An internet protocol address, an IP address. And therefore, that was concealment, and therefore the discovery rule applied that you don't start the statute of limitations until you discover the harm, until you discover the problem. So under that theory, this statute of limitations would have started more or less now when we all discovered that this was happening. Since it was not discovered until now, you should be able to go back an additional 2 years or 4 years or whatever the state's statute of limitations allows. So that's really cool and interesting and good for the class members. If the judge does allow this, then they will get additional damages for additional years. In other words, let me put it another way. If PayPal has been doing this for 10 years, but the statute of limitations is 2 years, that doesn't mean they got away with 8 years of it. It means we discovered it now, and as long as plaintiffs sue in the correct statute of limitations starting now instead of ending now, let's say that PayPal stopped doing it right now, you'd have 2 years to go back under the normal statute of limitations. By tolling the statute of limitations, you can probably go back the whole 10 years because it was intentionally concealed and hidden, not above board. No one is saying that the content creators explicitly agreed to this somehow, let alone that we don't have privity of contract between these content creators and the Honey browser extension. This was a big deal when I made my first video. I kind of forgot about this. Privity of contract is who is a party to the contract. If I make a contract, if party A makes a contract with party B, party C is not bound to it. It's that simple. So if Honey and PayPal make an agreement with a website or make an agreement with someone other than the content creator to do this affiliate thing, like the user, make this agreement with the user to use this browser extension, that's not an agreement with the content creator to redirect their income. That's not how that works. Although I'm assuming that's what PayPal's going to defend with, is that they had the right to do that somehow, that it was the user who was directing them, that the user chose to give the sale to PayPal instead of give the sale to the original marketer, to the original content creator. So, yeah. So we get another set of causes of action, unjust enrichment. Again, you got something you were not entitled to, unfair competition under California law, interference with prospective economic advantage or relations, conversion, you kept something that didn't belong to you, and that's that one. I don't see immediately any other Capital One cases. Ooh, it's also against WikiBuy and WikiBuy Holdings. Capital One owns WikiBuy. Okay, that's why that is. So yeah, the plot thickens. The defendants expand. The plaintiffs expand. This turns out to be one of the bigger scandals of our time, I think. This is like the online influencer scandal of the end of 2024, beginning of 2025. It's going to be a big deal through 2025 to uncover, to see what PayPal's defense is, to see what Capital One's defense is. What in the world, how could they possibly have thought that they were doing something legal? I bet that some lawyer type or finance bro type, some business bro type has come up with a way to justify, well, it's based on the last interaction and we are the last interaction, therefore we get the sale. And I'm really curious to see whether a judge or jury is going to agree. And obviously enough plaintiffs' attorneys believe that a judge or jury would agree with them that it's worth filing. Because they have to put all the investment into this. Like most of the time, the class representatives, lawyers don't get paid the full wage unless they win. There's some kind of contingency agreement. It doesn't mean it's not required. We don't have to know what that agreement is. At least, I don't know if I get to know. It might be that the class members get to know. I'm not sure. But that's usually what happens. And that's usually why the attorneys jump on these class action lawsuits, because there's enough of a reward, of a recovery at the end to make it well worth it. An attorney could potentially retire off of one good class action lawsuit. Of course, who wants to? You're having fun litigating. Let me know what you think about that in the comments below.